All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. Court from recess, now sitting.
Please be seated. Good morning. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
Thank you. The first case on the 10:30 a.m. docket for Monday, September 11th, 2023 is appeal number 124535, State of Kansas versus Richard Daniel Showalter, Shawnee County, briefs both sides.
May it please the court, Deborah Wilson, Capital Appeals and Conflicts Office, appears on behalf of the defendant appellant, Richard Showalter, present, ready for argument.
Good morning. May it please the court. The state appears by Deputy District Attorney Jody Litvin, present, ready for argument.
Second case is appeal number 124598, State of Kansas versus Richard Daniel Showalter, defendant, Matthew Douglas Hutto, appellant, Shawnee County, briefs both sides.
Good morning. May it please the court, Shauna Miller appearing on behalf of defendant appellant Matthew Douglas Hutto. We are present and ready for argument.
May it please the court, Chris Elsliger, Deputy Solicitor General for the state, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. Now ask the attorneys in 124535, State of Kansas versus Richard Daniel Showalter, to please come forward.
May it please the court, Deborah Wilson of the Capital Appeals and Conflicts Office appears on behalf of the defendant appellant, Richard Showalter. Chief Justice Lukert, I'm requesting 2 minutes rebuttal this morning.
Be the trend today. I will grant that. Yes.
Thank you. It also seems to be confrontation day. So, Mr. Showalter was convicted by a jury in the District Court of Shawnee County of 2 counts of first-degree premeditated murder, conspiracy to commit murder, and aggravated burglary. He was sentenced to 2 consecutive hard 50 life sentences, as well as some additional determinant sentences. And this is Mr. Showalter's direct appeal. I'd like to begin today with our second issue on appeal, which involves the admission of Dr. Glenn's deposition, which of course relates to our first issue on appeal, the admission of the autopsy photographs that came in through Dr. Glenn's deposition. The first thing I need to address, I believe, is the state's argument on page 33 of the appellee's brief that the autopsy photographs in this case were already in through the testimony of Detective Judd. These photographs were indeed identified by Detective Judd, and the defense entered their objections to the photographs, and the court ruled that they would be admitted over defense objection initially when Detective Judd testified. However, these photographs weren't referenced in any way during Detective Judd's testimony, nor were they displayed to the jury or published to the jury during his testimony. Rather, they were a part of a large submission of photographs. And while some of those photographs were actually the subject of Detective Judd's testimony and displayed to the jury when he testified, these photographs were not. Excuse me. The photographs in question were actually referenced and published over renewed defense objections when the deposition was read to the jury. Had the deposition not been admitted into evidence, the jury would have never seen the photographs in question.
Not true. If they had been admitted, wouldn't they have been available to the jury during deliberation?
No, Your Honor, and there's a few reasons why. First of all, any time that evidence is presented to the jury, that's a critical part of the trial that the defendant has the right to be present for. So if the photographs were just sent back to the jury room with the rest of the exhibits, then the defendant wouldn't have been present for that critical part of his trial, and that would deny his right to be present for trial. Additionally, both the defendant and the public have the right to a public trial. So if we just had photographs that were never displayed or published in the courtroom, then that would deny both the defendant his right to a public trial and the public to the public's right to a public trial. But there's a second completely different reason why they wouldn't have been admitted. Let's suppose for a minute that the prosecution decided, I think I'll get these pictures in through Detective Judd. There would have been solid objections on both relevance and foundation in that case, because although Detective Judd could have said, this photograph, for example, of a brain on a table, this looks like what I saw during the autopsy. That's a little bit of foundation for the photograph, certainly, but Detective Judd could give absolutely no evidentiary relevance to this picture of a brain on a table, for example. So, the question would be, why are we, the members of the jury, looking at this brain? What does this mean for the case? Detective Judd couldn't tell him that. We need the coroner's explanations as to the significance of the particular image to give it evidentiary relevance. So admitting them.
Excuse me, counsel, do you have any case law that supports your notion that the defendant has to be present? Well, that all evidence has to be displayed in the courtroom in order for it to go back to the jury room? That's completely contrary to anything I know about.
Actually, I can't cite the case. I had a case many years ago where they introduced a tape recording of, I think, a drug buy. They introduced it into evidence, but they never played it in front of the defendant, and it just went back to the jury room, and that was actually reversed on the defendant's right to be present. But I think we all know that the defendant has an absolute right to be present for every critical stage of the trial. And I can think of no stage of a trial which is more critical than the presentation of evidence to the jury. And so to admit some photographs and then just send them back into the jury room without any testimony about them, without the defendant seeing them, without the public seeing them, I think would violate the constitutional right to be present, as well as the right to a public trial.
Isn't that the defendant's through counsel responsibility to make objections before the exhibits are admitted?
And defense counsel did. Defense counsel objected twice, in fact. Defense counsel objected when Detective Judd said, here's a big package of photographs. Some of them are autopsy photographs. Defense counsel renewed their objections on the grounds that they were gruesome and irrelevant. And then, of course, they did again when the photographs were actually brought in and displayed to the jury.
But
he did-
Which happened during the deposition.
there was no objection to foundation.
No, you're right. There was no objection to foundation. It was the pretrial objections. But once again, what would happen if Detective Judd just said, here's some photographs of the autopsy? Well, now we have a situation. This court has often said in the context of autopsy photographs that if the images serve only to inflame the passions of the jury, then to admit them would be an abuse of discretion. If we have these horrible, horrible pictures just shown to the jury with no explanation, what am I looking at here? Well, here's some pictures from the autopsy. but with no explanation, with no testimony to put them in context or give them relevance, then what we have is horrible images that are admitted solely for the purpose of inflaming the jury. Now,
Let me ask a question. I'm getting really confused in conflating the issues here. So we're on issue one?
yes, and I just wanted to, the reason we took this detour was that the prejudice from the admission of the deposition was these autopsy photographs, because they came in with the deposition testimony. And
Okay, but let me, I thought you conceded that those autopsy photographs were relevant,
yes,
and I'm not showing a relevancy objection. It's,
you're right. The objection that was made at trial and our argument too,
unnecessarily graphic, repetitive, and only minimally useful.
right, more prejudicial than probative, right?
Right, and then, okay, well, once it's relevance, then we go to the
Exactly.
next step. But so why are we arguing relevant? I don't, if it wasn't preserved below the relevance when it came in through Detective Judd's testimony.
What I'm arguing is it never came in through Detective Judd because he didn't testify to them and they weren't published or displayed to the jury. So I'm just addressing the state's argument, oh, they were already in, but they actually weren't. They were never shown to the jury during Detective Judd's testimony.
Wait,
They came in with the deposition.
aren't exhibits either admitted or not admitted? I mean, I've always considered that to be black or white, either it's in or out. And all objections need to be made before it's in. Is that incorrect?
Yes, and the objections were made. I was just answering the question of why you couldn't just bring them in through Detective Judd with no testimony. And of course, they didn't try to do that. So I think if they had tried to do that, then the defense would have had a good objection that it's irrelevant without an explanation from the prosecutor, but that's not what happened in this record.
So the exhibits were admitted
Without a relevancy objection.
Right.
through
Right. At
Detective-
that point.
through Detective Judd. They were admitted by the
Right.
court into evidence.
But the jury did not see
I
that.
understand
Right.
that, but I need confirmation of that.
That's true. That is absolutely true. Yes. And I'm arguing that because the jury didn't see them then, they did not actually come in. And they went through the whole rigmarole again of offering and renewing objections at that point through the deposition. So this is a detour on the way to the crux of the issue was whether the deposition should have been admitted. With regard to that, it appears at first that Mr. Showalter might be at a disadvantage because you've already decided in State versus Keys that Dr. Glenn's deposition was properly admitted in a different Shawnee County homicide prosecution due to his relocation. But Mr. Showalter's case is different factually and legally. And since I only have 2.5 minutes, I'd like to talk about the facts here. In Keys, Dr. Glenn stated specifically, I am willing to come back for cases. I can't come back for Mr. Keys cases because I won't have been in my new job long enough to do that. He said, otherwise, I'm willing to come back. But I just want to tell everybody I can't come back for every case. And so in this case, we have Dr. Glenn who never said until the day before trial, I can't come back.
But the paralegal testified that she was in contact with him through email and that he wasn't coming back for other trials, right?
He wasn't coming back for other trials, but we don't know if those were also cases where he only got a day's notice. And that's the problem in this case. And I'll just skip to the nub of.
Does the record show, before you go there, does the record indicate how long the travel restrictions, as I understood it, the barrier the day before trials, that there had been travel restrictions in place that prevented him from actually making that travel? Does the record reflect?
I think what the prosecutor said is that the defense counsel said, well, no, people are traveling now. And the prosecutor said, well, if he goes back, he has to quarantine for 2 weeks. I think that's what it was. But here's the thing. Dr. Glenn could have said, I'm not coming back because I don't fly when Venus is in retrograde. It doesn't matter why he said he wasn't coming back. The question is, did the state make a good faith effort to get his voluntary attendance? The state knew for 7 months when this case was going to be, when this case was set for trial. The state waited until the day before to ask him to come back. And here's the thing, if we say this is a good faith effort to secure a witness's voluntary attendance, that means the state can render any witness unavailable for confrontation purposes by giving them late notice. Had the state said to Dr. Keyes or Dr. Glenn, 7 months before the trial was set, can you come back in 7 months' time? He may have said, that's a perfect time for me to visit my family.
Well, he did. It was 7 months in advance. And he said, this is a new job. I can't come back for all the cases. I may be able to come back for some of the cases.
He actually said that a few years, maybe a couple of years before the trial was actually set, because this case was, of course, interrupted by COVID. When he gave his deposition, he said, I'm willing to come back. I just can't come back for every case. And what we have on this record is his first notice of this case was the day before trial. And so we can't, confrontation rights are important. And to allow the state to just render a witness unavailable by not giving them adequate notice of a trial would render the defendant's confrontation rights subject to the whims of the state.
Is there anything in the record that indicates Dr. Glenn said he didn't have enough notice?
No, he just said travel restrictions, whatever that means.
And from your perspective, our standard of review of the district court's findings of a good faith effort is discretion or what?
I think it's a mixed question of fact and law. And I think that we can meet the, and well, if you'll give me a moment, part of the problem here was the district court's belief that all the state had to show was that Dr. Glenn was not compellable. And that was a ruling that the court issued sometime in the year before the court actually set trial. You might remember what happened was the defense entered the prosecution filed a motion to admit the deposition testimony like a couple of years before the trial actually happened. Defense said, we object on confrontation grounds. The trial court said, I'm not going to decide yet if the witness is unavailable. I think we need to wait till closer to trial. But then with no real explanation in the record, the trial court said, well, he can't be compelled, so I'm going to find him unavailable. And then a few months later, the court set the case for trial, giving everybody 7 months notice. It's my speculation that when the court entered that order saying, oh, if he can't be compelled, he's unavailable, the prosecution was just like, okay, that question is settled. But of course, that was a legal error on the part of the court, because of course, Crawford versus Washington says that you have to show that the witness is unavailable, and cited Barber versus Page. And in Barber versus Page, they said that you have to try to secure the witness's voluntary attendance before we can just say that the witness is unavailable.
So the 6459 definition of unavailability is just a part of the equation.
Well, we're talking about confrontation rights here.
Right. So in addition to that definition of unavailability, you have to add the
good faith effort.
good faith effort.
And we just don't think that when you've had 7 months notice of the trial, waiting till the last day is a good faith effort. Now, if
Be
they,
taken, the record, is the record have anything about travel restrictions? I mean, we know just if we were paying any attention to what was happening in the COVID world, that New Zealand was on the far end of the spectrum and very tight. And well, in fact, zero travel for a long period of time and then very strict travel restrictions after.
yeah, there
But
was.
none of that's in the record, I take it?
None of that's in the record in the form of testimony, but it is definitely in the record in the form of the discussion between the court and counsel. Defense counsel pointed out that restrictions had been lifted, that people were able to travel to and from New Zealand. Prosecution pointed out that, oh yes, but if you go back to New Zealand, you have to quarantine for 2 weeks. So that's what we know
Actually,
from
that's
this record.
May have actually been 3 weeks, but whatever.
It could be,
Um,
might have been.
But so, but does that, the fact that there were those travel restrictions and those quarantine requirements impact the good faith effort analysis?
Oh,
that,
I think I know what you're asking. I think you're asking, what you're asking is, well, if they'd given Dr. Glenn notice, he still would have said no.
Well,
because
not-
of travel
Not so much that, but just knowing that New Zealand had those strict restrictions for a period of time. But we don't seem to have a record here of when those were lifted in relation to the trial or any of that kind of thing. Because at one point there was just no in and out.
Yes,
You left, you stayed out.
and I'm going to return to my first assertion, which is it doesn't matter if Dr. Glenn had a good reason or a bad reason, because he couldn't be compelled. He could have just said, I'm not coming because you can't make me, as long as the state made a good faith effort to say, would you please come back, and gave him time. And the other thing is I'm going to return to my new favorite case, Barber versus Page, in which the United States Supreme Court said the possibility of a refusal, or maybe they even said the probability of a refusal, is not the same as asking and receiving a rebuff. All we're saying is that the prosecution was required to ask in a timely fashion, can you come back for this trial? And once again, if we say that the prosecution can wait until the day before trial to ask, then the prosecution has the power to render any witness unavailable just by giving them late notice.
And so to determine harmlessness here, we just strike the testimony. And in your view, the view of the photos, the autopsy
Right.
photos.
Because I can't stand in front of this court and say, oh, they couldn't have proved murder without the coroner in this case. The facts of the crime speak for themselves. It's clear these people didn't die accidentally or by natural causes. But I'm going to continue to assert that you can't just send pictures back to the jury room that haven't been displayed in the defendant's presence in open court. So those photographs would not have been there to inflame the passions of the jury.
Counsel, let me just ask you, what, that argument you made right there, is that in your brief?
No, I didn't file a reply brief when the state said, oh, they came in through.
This is a brand new argument that you're bringing up.
Well, we argued that they weren't admitted, that they were admitted through the deposition. We did argue that. I was surprised that the state said, oh, no, they were admitted through this witness who didn't testify about them.
Quick procedural question. Was this deposition compliant with 22-3211?
In what way?
Well, specifically, was the defendant present?
Yes.
So we
Yes.
don't, this isn't a confrontation question then.
But it is, because Crawford says to admit out of court testimony, there's two things you have to show. And the second thing is that there was a chance for cross-examination. But remember what the first thing is, the witness is unavailable.
I understand that.
Yes.
I guess what I'm saying is you're not making a constitutional confrontation argument. You're making an argument that the statutes were violated.
No, we're arguing that under Crawford, you didn't show the witness was unavailable,
Right.
which is one of the constitutional requirements under Crawford.
May it please the court, the state appears by Deputy District Attorney Jody Litfin. I will jump in just with issue 2 as well. The portion of the brief that I wrote about the photos coming in through Detective Judd, as Your Honor pointed out, that was not raised. I mean, the part about them not being admitted or not being shown to the jury, that's new that I'm hearing for the first time today. I would just say that in our brief that we wrote, the point of that was being the photos were actually admitted through Detective Judd. They were not admitted through Dr. Glenn. So that was the state's purpose in putting that there. And our position would be when they're admitted, like Your Honor said. There's no showing it to the jury to have to be admitted or right to violation of a right to a public trial or to the defendant's right to be present.
Could the detective identify the photos? If they had been offered individually, yes, this indicates this indicates that. Could the detective, given the specificity that's normally required of photographs?
That's a question for relevance, I think, to the relevancy of those photographs. He was there for a foundation.
And accuracy, all the stuff that needs to be laid before photographs are admitted, and then what they're depicting. I assume the detective is not a coroner that could specify autopsy photos.
Correct. I mean, he couldn't talk about the nature and extent of the injuries that were shown in the photo, correct, but he was a foundation witness. And we did get because he was present at the autopsy. So I guess that was a whole issue that we didn't really address. But to go to the heart of the issue, it's a question of reasonableness here. Our position is that the district court's finding that Dr. Glenn was unavailable was not an abuse of discretion. And this court should find that there was no violation of a confrontation clause here.
But what about the 1-day notice? Because I think what opposing counsel is saying is if we say that, where did I write this? 1-day notice, and then I actually haven't read the Barber versus Page opinion, but the probability of refusal not the same as a rebuff. But 1-day notice, is that what our standard's going to be going forward for unavailability?
I think it's a question of reasonableness. I don't think that the evidence here is not 1-day notice by the state. That's not what we have. We called 3 witnesses, excuse me, in this hearing that happened outside of the presence of the jury. And to disagree with the statement, well, the statement from Barber is, yeah, more than a probability of refusal. We have that. We have more than a probability of refusal. We have a refusal. And yes, it is the day before, but as Your Honor noted, the legal assistant had been in contact with Dr. Glenn, mostly by email, occasionally by phone, for years regarding his testimony in numerous homicide trials. And to take it back to where we began here, the parties agreed to this deposition back in 2018. Prior to Dr. Glenn leaving, there were numerous depositions that had to be done because he was moving to New Zealand to pursue to be a forensic pathologist there. So this was agreed to by both parties. Granted, the defendant did get a new attorney after that, but it was agreed to. The deposition was for the purpose of his possible unavailability. And really, in all likelihood, the parties did it because he was going to be unavailable because he was going to be in New Zealand. So I don't think that this is the state pulling one over, doing this 1-day notice, making it look like we can just turn any witness into an unavailable witness that way. We would argue that it was good faith efforts were met here. I don't know that my brief is super clear on what Your Honor was saying about, is this really a confrontation clause issue versus the statute? It doesn't look like it was ever argued as a true confrontation clause issue from the motion, or maybe the response to the state's motion to get the deposition added. But
Since you brought that up, I'll follow up with my,
okay.
what spurned that line of questioning was the the provision in the statute that requires the defendant's presence at these depositions. Does that change the analysis if it's under the confrontation clause? Because he was present and I mean, arguably, there was that right of face-to-face confrontation was satisfied even in the deposition context.
Correct. I don't think so because he was present, his attorney was present and they had cross-examination.
Well, it's the defendant's face-to-face presence that strikes me as more important.
And he was there, yeah. So, no, I don't think it does change it.
Well, it doesn't change anything, or
I think he was present. I mean,
in other words, are we?
an understanding.
Well, this question of availability, unavailability is woven into some of the Sixth Amendment case law, but it's also written into our statutes as to when you can bring a deposition in. My question is, if the statute that authorizes the deposition incorporates confrontation, do you still have to do that analysis?
Separate.
A separate Sixth Amendment confrontation analysis?
I mean,
And the
if
reason
they're
this-
covering the same thing.
Well, the reason this actually might make a difference in the case is it would arguably at least create, dictate a different standard of harmlessness as to whether this is a statutory error or a constitutional.
Right. And
You
the
have a
burden of
position
proof,
on that?
in the burden of proof. I mean, I want the easier one. I suppose the state would argue for, having
Can
the
you
lesser
make an
burden.
argument for that? Or
Um,
have you made an argument for that?
I don't think so. I think the way that I addressed it was under the state having the burden to prove harmlessness. So,
A constitutional harmlessness.
correct. If there are no further questions, I think,
Can
the
I-
state,
Can I ask about Barber versus Page and its applicability here? As I understand Barber versus Page, it was, the question of a witness that was in Texas testifying in Oklahoma. And that part of the court's reasoning was that there are now statutes that allow for the service of a subpoena in another state. But here we're talking about a country, a different country. Do those same kinds of considerations that the court took into effect in Barber versus Page apply here? When we're talking about someone that's outside the subpoena authority of the state because they're in another nationality.
I didn't really address that, in my brief. I mean, I think it's a different issue when we're talking about a foreign nation where we have no subpoena power. I mean, where the court really has no jurisdiction to compel the witness to come back. So I think it does change the standard, I guess, of reasonableness in what the state has to do in order to show that they've asked the witness to come back. So I guess it would be just, again, that questionable of reasonableness in requesting them to come back from that foreign country as opposed to another state. And the fact that the court does not have the same avenues to compel them to come back as it does from state to state. So I guess my answer would be no, it doesn't have the same considerations. It's different. And this is also not a situation where it's some sort of temporary, unavailability, where there's some case law. There are some cases that talk about military leave or pregnancy or things like that, where it's temporary. I think this duration is long-term. He's moving there, he's accepting a job there, he's going there. So I think that affects the reasonableness of it as well. And not to mention that this all happened, deposition was taken prior to the pandemic, but then the pandemic hit and kind of all bets were off as to what was happening with trials and that sort of thing. So I think that also plays into the reasonableness of efforts here, considering that this happened during a pandemic. And 7 months prior, when the trial was set for July of 2021, that was in the middle of a pandemic. So we didn't know if that was even going to go then in 2021. So I think that that all plays to the reasonableness and should have an impact on the state's efforts here in asking Dr. Glenn to return.
Did Dr. Glenn return for any depositions once he relocated?
Any depositions or any trials?
I'm sorry, for
Any
any
trials?
trials.
I don't know, Your Honor. There's no evidence in the record that he did. And I would agree with counsel's, statements about what we have in the record about travel restrictions and the 3-week quarantine, that there wasn't anything that the legal assistant said, or there wasn't evidence presented, but just the prosecutor's statements that there was that 3-week quarantine period, which again goes to the reasonableness of asking Dr. Glenn to return for a trial, for a week-long trial, where we'd have to testify and then return and not go back to work for another 3 weeks and possibly get sick and, have to quarantine longer.
Is
So-
there any evidence in the record that Dr. Glenn actually received only 1 day notice? Nodding.
The testimony from the legal assistant is that he received an email the morning before the trial was supposed to begin. And that she received an email that evening that he would be unavailable due to travel restrictions, is my recollection. I do have the transcript, but I think that's what we are stuck with.
Well, the travel restriction would be impossibility. If he gets notice the day before he's supposed to appear and he's in New Zealand, I don't even know if there's travel time available for him to appear.
I don't know the answer to that, Your Honor. I mean, we can speculate that he could have hopped on a plane, testified at the end of the trial. This was a week-long trial. I can't remember exactly how many days it went, if it went 5 or more. I don't think the restriction was coming into the United States. I think it was leaving. But again, we didn't get into the travel restrictions when all of that evidence was being taken. So, I guess I have no further argument unless this court has further questions on any other issues. We would just ask that the first-degree premeditated murder convictions and the conspiracy conviction and the aggravated burglary conviction are affirmed in this case.
You know how much notice the state had that the defense was objecting not appearing in person? That in the record?
I don't know if that was included in their response to the motion to admit his deposition when that was filed. Honestly, I don't
Opposing
know.
counsel is nodding again, so I'll ask her.
I'm sorry, Your Honor, I don't know. I mean, I know that it changed after the counsel who agreed to the deposition, their stance, once he withdrew, a new counsel was appointed, changed. So I think that may have been addressed in their response. But I'm not sure the date that was filed, but I know it was. It could have been in 2020. I can't answer. I don't know, Your Honor. I'm sorry. Okay. Thank you.
Trying to hurry up here before I lose my place in these papers. Okay, Justice Wilson, in April, this is set out in the brief, in April of 2019, the defense objected on Sixth Amendment grounds to the prosecution's motion to admit Dr. Glenn's deposition. In the state's motion, the prosecutor candidly admitted that Dr. Glenn had indicated a willingness to return for the trial, but it also said, but I might not be able to. 7 months later, in November of 2019, the trial court heard the defense confrontation objections and said, I'm not going to decide yet. I'm going to make a determination as to whether Dr. Glenn is unavailable closer to trial. For reasons we don't know, 6 months later, in May of 2020, the court just said, well, Dr. Glenn can't be compelled, so he's unavailable. So that's what happened there. Then,
Well, wasn't that, there was a trial setting of April 28th. And so that May 1st has to do with that. The trial was continued indefinitely, because of course, that's just like 1 month after COVID.
right,
And at that point, it had not been reset. And there's a pending motion to admit the deposition testimony at the pretrial conference, which was, I guess, the day before. And that's when the judge made a decision, right?
and I've got it down as May 2020 in a written decision, but that you
Oh,
could-
right, because
Yeah, you could be-
4/28, there's only
Yeah,
2
yeah.
days difference
Yes,
there.
you could absolutely be right there.
And let me
Did-
just ask one other
Okay.
question. So in looking at Keys again, they asked him to come back during trial in Keys. Those were the facts. So in this case, it was the day before trial, but in Keys, it was the day after trial. The only distinguishing fact is that he said in his deposition, or I guess, in his this was all before the pandemic. He said, I may be able to come back for some, but I can't come for this. I can't come for Keys
I
trial.
can't come for keys.
Right. So that is hanging right there, in the months prior to trial. That is what you're hanging your hat on of why we should deviate from our decision in Keys.
Yes, well, that's part of, obviously that's part of it. And I do have the part of the record where the legal assistant testified. Here's what's important for me. The defense counsel said, Ms. Gonzalez, when was the first time that you emailed Dr. Glenn about this current trial setting? Answer, yesterday.
Right, but in Keys, it was after trial started. So that was the fact in Keys.
But I think, didn't he say beforehand, I can't come back for keys? I thought, I may have misread the opinion, but I thought he said beforehand, I can't come back for keys. But I could be wrong about that. But so prior, I'm going to go back to the testimony. Prior to yesterday, you never asked whether he was available for this trial that started yesterday. Correct. Okay, and so as of yesterday, he couldn't get on a plane and be here yesterday. Now, of course, you know what the other difference is with Keys? This court didn't reach a confrontation claim because it wasn't preserved below. But it's preserved in this case.
Well, what do you mean it was obviously preserved? In
Well, back in the defense, when the state filed their motion to admit it in April of 2019, the defense filed a written objection arguing the admission of the deposition would be a violation of his confrontation rights under the Sixth Amendment. That's in volume 1, pages 299.
That was for the what date was that?
That would have been in April, excuse me, of 2019. And if you look
Well,
at.
it says state failed to establish Dr. Glenn was unavailable under 22-3211 subsection 8.
And also argued that the admission of the deposition would be a violation of his confrontation rights under the Sixth Amendment. Volume 1, pages 299 through 302.
So that was orally, they argued that?
I believe that was, it may have been, no, that would have been written because it's in volume 1. So
Okay, volume 1, and what were the pages?
299 through 302.
And that confrontation argument was
Yes,
developed.
yeah, the confrontation argument was made. And so I wanted to read to Justice Stegall this passage from Crawford versus Washington, where testimonial evidence is at issue. However, the Sixth Amendment demands what the common law required: unavailability and a prior opportunity for cross-examination. It might not be important, but unavailability is the first thing they say there. And once again, I will just reiterate, we have a witness who said, I'm willing to come back, even though you can't compel me. But if you say the state can wait until the day before trial to ask a witness from New Zealand to be present, you put unavailability in the hands of the state.
Counsel, real quick, do you know of any cases that have answered that question, that specific question I was raising about whether or not the statutory requirement that the defendant be present at the deposition resolves or satisfies the Sixth Amendment's confrontation rights?
I don't know any cases that say it does, but that
Say it does or say it doesn't.
That doesn't mean there aren't any, or there
Yeah,
are. But Crawford requires unavailability too. That's what we're hanging our hat on.
I'd like to ask you the same question I asked about Barber versus Page, because I pulled it up to see if my memory of it was correct. And it did deal with a witness that was in Texas for a trial in Oklahoma. And in it, the court notes and acknowledges that the past rule has been that if a witness is outside the state's subpoena power, then the witness is unavailable. But it goes on to say that given it preferences it by saying whatever may have been the accuracy of that theory at one time, it is clear that at the present time, increased cooperation between the states themselves and between the states and the federal government has largely deprived it of any continuing validity from the law. But is the same true when we're talking about subpoenaing somebody internationally? Or do we default back to that prior rule that if you're outside the subpoena power of the state, you're unavailable?
I don't believe so because, Dr. Glenn was, for all we know, a willing witness. And to say that if someone's in a place where I can't subpoena them, I don't even have to ask them, I can't force you to come back, but would you be willing to come be a witness in this case? I think that's the valid rule, that you have to make a good faith effort to get the witness there. Now, you don't have to move, to the ends of the earth to do it. All this would have required was, the case has been set for trial in 7 months. Let's email Dr. Glenn and see if that might fit within his plans to come back to visit family or attend a conference, or can you fit us in 7 months? That's all we're saying should have happened in this case. Not, I've never communicated with Dr. Glenn about this case until the day before trial. That's not a good faith effort.
I would just note that I went to volume 1, 299, 302. The only time that the Sixth Amendment or the US Constitution is in like a little summary sentence at the end.
But they did raise it. They did.
Well, it
raise
wasn't even raised at the beginning of the, it was about using, let me see the name of the pleading. It's response to state's motion to admit prior testimony. It's just all that is cited here are statutes. And it's an undeveloped argument.
But the argument was made.
No argument. I mean, a reference was made.
A
to the
brief
Constitution.
reference.
It's just the same thing as a defendant saying, well, this would violate my constitutional rights. Now we get up on appeal and let's look at the buffet of constitutional rights that are here.
Well, we're not
This
asking.
motion specifically says it's objecting on 2 grounds. That's the opening paragraph here, on 2 grounds, and both of them are statutory. So again, the fact that at the end you throw in the Constitution, it's an undeveloped, what you're trying to argue was not argued to the district court.
I think that the district court and the prosecution was put on notice that they were raising their Sixth Amendment confrontation rights. And Justice Files, we're not asking for the whole buffet. We're just asking for the hors d'oeuvre of the Sixth Amendment, and it was raised below. And I think the order it was raised in, or how many words that were used to argue it, doesn't change the fact that they said we are asserting our Sixth Amendment confrontation rights here. Thank you.
Thank you. The court thanks both counsel for your arguments in this matter. We will take this case under advisement. Now call 124598.
May it please the court, Shauna Miller appears on behalf of defendant appellant Matthew Hutto. We're present and ready for argument.
Please the court, Chris Elsley for the state, present, ready for argument.
May it please the court, Shauna Miller on behalf of defendant appellant Matthew Hutto. Chief Justice Lukert, if I could reserve 2 minutes, keeping on with apparently what's the amount of time for the day.
Hate to break that, right? Yes, certainly. Good. 2 minutes is granted.
Right, thank you. May it please the court, this is a bit of a spinoff from the arguments that you just heard on the Richard Showalter case. This matter involves a witness that was actually called in Mr. Showalter's trial, Matthew Douglas Hutto. Mr. Hutto also was charged with similar, if not the same crimes as Mr. Showalter ultimately in his Shawnee County matter 18 CR 1936. He ultimately decided to enter a plea in his case, specifically a guilty plea, and he was sentenced in his matter on May 10th of 2019. Just a few days later, though, he did file a pro se motion, essentially asking the court to for permission to withdraw his plea. The court ultimately denied that, and he appealed that to the court. Ultimately, the Supreme Court issued a decision on July 9th of 2021 that the district court was correct in not allowing him to withdraw his guilty plea. The reason that that is important to this case is that it was on July 13th of 2021, and then a few days later, ultimately on July 16th of 2021, that Mr. Hutto was called to testify as a witness in Mr. Showalter's matter by the state. Mr. Hutto invoked his Fifth Amendment rights to not be compelled to testify in that matter. And ultimately, the court adopted the arguments of the state, which were twofold. One, that the state had offered him use immunity, which ultimately that's not an issue before the court today. But then secondly, the state the state argued, and the court adopted the state's argument, that Mr. Hutto had pled guilty, been sentenced, and their argument was that because the Supreme Court had issued a written decision on July 9th of 2021, that Mr. Hutto no longer had his Fifth Amendment ability to not testify in Mr. Showalter's case. I would point out factually that ultimately the mandate was not issued by the Supreme Court until later, which was August 13th of 2021. Now, the district court judge ultimately, after giving Mr. Hutto the ability to think about it a little bit, possibly purge himself and agree to testify, ultimately imposed a contempt sanction on Mr. Hutto on July 16th of 2021 for 6 months county jail time to run consecutive with the sentence that he ultimately received in his own criminal case. Now, why are we here today? Obviously, we have some cases that can, at least by interpretation, be somewhat contradictory. Specifically, as cited in Mr. Hutto's arguments, was the Smith case that appears from its finding to extend a defendant or a witness's ability to plead the fifth, pass the final judgment, and a right to appeal has expired. It's the argument of Mr. Hutto that because, in part, because the mandate had not been issued yet, that his appeal process was not concluded. Also, there were some other various remedies that he could have explored to further the appellant process. And ultimately, it's his argument that he still did have the right to invoke his Fifth Amendment.
Is there a point
to
in
not
time where
testify.
the right to invoke is not in effect? I mean, this was in between the time we issued the decision and the mandate. Had the mandate been issued, would that have been sufficient? Or is it if he'd taken cert, is it after that? Is there a period of time that you're taking a position on where the invocation is no longer available?
Well, I will say one thing, that is two things actually, but one thing is that is one issue that we're asking for clarification of this court from, because I think there's enough difference in the opinions that does need to be clarified. When does that end? I think that it would have been much more clear if Mr. Hutto's mandate had been issued. I think it would have been much more clear. However, I'm not also going to say that another attorney couldn't come up here and argue that he still had remedies with federal habeas corpus or other things. Now, those are, maybe more civil in nature, but I think it would have been extremely more helpful and a bit more clear in Mr. Hutto's situation in particular if the mandate had also been issued, because that is truly a final issue or order from this court.
Let me ask you, so if you just track the timeline, so plea And then he's convictions and sentenced. And at that point in time, there, under our current statutory scheme, did he have a right to appeal?
Yes. Once he had pled guilty and been sentenced, did he have the right?
Pursuant to plea agreement?
Yes.
What, does the statute not limit the right to appeal for, based on plea written on the record?
Limits it significantly, but it does not completely,
Okay.
it does not completely take away any appealable rights.
What would remain appealable at that point in time?
One thing that, for example, that comes to mind would be ineffective assistance of counsel, would be that his attorney was insufficient, and that could be a direct appeal issue, not necessarily, obviously habeas corpus also, but that could be a direct appeal issue. That's just one example that would come to mind.
What about the possibility of innocence or proof of innocence? If it was a DNA case, then does it not end until?
And that was another concern that I had, just in my practice, is that there are situations, unfortunately, that people are, do enter pleas, even guilty pleas, and are sentenced. And ultimately, as the court suggests through DNA evidence, or even as other evidence is developed, it's found that they're actually innocent. And so that was another concern that I had thought of is, there, things like that do happen. They
So
do.
it never ends.
Well, I mean, that is obviously an argument that the state has, that the Fifth Amendment right never ends. I think that, in thinking about this, obviously the Fifth Amendment right to not be required to testify against yourself, to cause yourself self-harm, is probably one of the most important rights that we have, especially in the criminal system. And so it is a very slippery slope as to when does that end and when do we say is enough enough? Does it end when all appeals are exhausted? Does it end when the DNA test results come back? I don't have a great answer to that. I would say, though, in Mr. Hutto's situation in particular, again, I think that mandate would have been an extremely important kind of final order by this court to stop that. But that's a very good concern, because I thought of the same in true innocence type situations.
Did you raise the mandate argument below?
Yes. Yeah. That the mandates did not come out until after he had testified, and that would be a final order from this court. I also raised, obviously, that there was other things that he could have done, such as Supreme Court Rule 706, motion for rehearing, things of that nature. Those things are all still viable options until the mandate's issued.
I should know this already. I don't. Is there US Supreme Court case law that clearly says the Fifth Amendment right ends at some point?
Yes,
Is that
so
just
that
in
would
state
be, I know I wrote it down here. I believe it was at the Mitchell case. I know it starts with an M. I know the state cited it in their brief.
That
Yes, Mitchell versus United States. They specifically say that the privilege does extend to sentencing. What they don't address is that it?
right.
So I think there still could be room for interpretation until it's clarified.
So at least as far as you know, there isn't a decision from the United States Supreme Court that definitively says it's done. You don't have the right any longer.
Not that specifically says that. The closest we get is the
Which is
Mitchell
why-
case.
And I'm presuming here, I presume that's why these arguments all are turning on essentially a string of decisions from this court.
Right, right. And I would concede that the state definitely has a point that some of these opinions can be interpreted different ways. The Smith case could, does it open through appeal? Obviously, the state will likely argue that the Bailey and Soto case distinguish it. So again, ultimately, I think it would be very helpful for this court to be as clear as possible and clarify when is enough enough? When does that Fifth Amendment right truly end, as far as being able to be compelled as a witness to testify possibly against yourself?
And I circle back to my earlier question. Now I pulled the statute up under 223602 subsection A. It says, no appeal shall be taken by the defendant from a judgment of conviction before a district judge upon a plea of guilty, except that you can then raise a 1507, a post-conviction remedy.
Right. Without having the benefit of having that statute in front of me, I know that even in cases where somebody could appeal and or sentence, for example, another example would be illegal sentence. So I believe that there should be qualifiers, if
That's
not contained in that statute elsewhere, that there is still the ability to appeal, although they are significantly limited, obviously.
Well, that wouldn't necessarily be a direct appeal. That's a motion to correct an illegal sentence, sort of a collateral attack. I mean, it's a separate vehicle, I guess.
Yeah, I mean, yes.
Challenge. Okay. I was just wondering if there's a way we can reconcile Anderson and the other cases that, you know, at that point in time, there actually was, you know, there was no direct appeal right at that point in time. And you see how that would create some consistency with that general rule.
Yes, absolutely, absolutely. You know, I guess another option to throw out there is the state always has the option of offering immunity, which they did partially in this case. They just didn't offer the full immunity, which I think ultimately was fatal in this case. The state always does have the immunity option if they do it appropriately. And so maybe this court keeps the Fifth Amendment available at all times until or unless they're offered immunity. That's just another way to throw that out there, because I do agree that it's a slippery slope on when does that Fifth Amendment truly end in the appeal process? Is it sentencing? Is that a bright line rule that we really want to impose on people? Any other questions? All right, I'm going to turn it over to the state at this point. Thank you.
Please the court, Chris Elsliger, appearing on behalf of the state. You know, opposing counsel prefaced my argument fairly well there. We have one, the reason we're here, we have this kind of one odd case that seems to, whereas most of the case law says that the Fifth Amendment right ends when, and this is in the context of when a person has pled. So this person has pled guilty. So already incriminated themselves in open court, right? Pled guilty and been sentenced. The case law all tends to supports the position that after sentencing, that's when the Fifth Amendment right terminates, unless before sentencing, the person had filed a motion to withdraw the plea. That didn't happen in this case. He did file a motion to withdraw the plea after sentencing, and that's what the appeal was about, which is how he was able to appeal. Justice Wall, to get to your question, he wouldn't have been able to appeal the from the plea, but he filed a motion to withdraw plea after sentencing. That was denied, and he appealed that denial. But we've got this one case, State v. Smith, where just some inartful language, because it wasn't really the Fifth Amendment. This type of situation wasn't really at the crux of the case. But the court said the Fifth Amendment privilege against self-incrimination extends until there's a final judgment in the case and a right to appeal has expired. And it's kind of ambiguous. I mean, what that actually means. But the case with that, in that case, you had something like 5 co-defendants who had been tried together, and they were arguing on appeal that their case should have been severed. And part of the reason they were arguing that severability was because they would have been able to call one of the other co-defendants. And so this kind of came up as a tangential part of that. The court was saying, well, it wouldn't have mattered because they could have still claimed the Fifth. In fact, and nobody in that case had pled or anything at that point in time. So that language, it wasn't, again, it wasn't even really the issue on point in Smith. And it was sort of on a secondary issue. When you look at the cases that actually address this directly, like State v. Longobardi, which is kind of what I opened with in the brief. I mean, this court said that once a plea of guilty has been regularly accepted by the court and no motion is made to withdraw it, the Fifth Amendment privilege against self-incrimination ends after sentence is imposed. And it spoke directly to, when it talks about a motion to withdraw, before sentencing.
Counsel, I guess my question is, do we even have to distinguish Smith? Because the way it looks to me is in a case like this, when you have a plea that's entered and sentence is imposed without objection, the right to appeal has expired because there is no statutory right to appeal.
That is a perfectly reasonable way to read it. Like I said, the language in Smith, like I said, is a little, it's a little ambiguous what it means. And that's how, I mean, and that was, but that's what was raised by opposing counsel in the brief, was that this language in Smith, because you can read it, could read it more broadly. But you're right. I mean, that's an entirely possibly, correct way to read Smith. It's just that Smith lends itself to other interpretations as well. I mean, you could simply clarify that that's what Smith meant. Because certainly cases that followed Smith, as she pointed out, Soto and Bailey, I think Bailey was almost this exact situation. And the Bailey court said that, yeah, it ends when he's sentenced. And that's it. Otherwise, I mean, the other, if you go the other way, then you've got this open-ended, well, they could file a 1507, and they could file federal habeas, and sometime far down the line, years from now, they might get their, no matter how remote the chances, they might get their conviction overturned, and all of a sudden they want their Fifth Amendment right back. And I think, as the Court of Appeals below pointed out, you can't have this, you would have this sort of Fifth Amendment right being extinguished and then reestablished and extinguished. It just doesn't make any sense. In the case where a person has pled guilty and been sentenced, the case law pretty clearly says that's the end of the Fifth Amendment right. It's just we have this.
Well, that's what some of the state case law may say. Do you know if there's U.S. Supreme Court case law that says it?
Yeah, well, we cited Mitchell v. United States, and
I am also looking at Mitchell.
yeah, and it kind of suffers from the same problem because it has that little ambiguity there.
Yeah, I'm looking specifically, and I wanted to ask you about this line, that the U.S. Supreme Court's guiding light seems to be when they say, if no adverse consequences could be visited upon the convicted person by reason of further testimony, then there's no further incrimination to be. So if that were the rule, seemed to me that would cut in favor of the defendant here.
Well, but the U.S. Supreme Court went on to say the principle applies to cases in which the sentence has been fixed. And then comes the little bit of ambiguity, and the judgment of conviction has become final. Then it's, well, what does final mean? But the federal courts, the lower federal courts, I think, have pretty much universally interpreted that to mean just what I'm arguing now, that once the sentence has been imposed, that's when the Fifth Amendment right ends.
As opposed to the sort of more amorphous, no adverse consequences.
Yeah, because I think you have to read in Mitchell, they kind of qualified what they meant by no adverse consequences is conviction, sentence, then we're done. Because the possibility sometime down the road of an appeal succeeding or some collateral, that's too amorphous. And then
Is it too amorphous in this case where post-sentencing, pretty contemporaneous with post-sentencing, there's a motion filed to set aside the plea? And I think the standard after post-sentencing is manifest injustice. It's hardly a standard that ever gets met. But what if it did get met and he was compelled to testify? Wouldn't that be an adverse consequence? I mean, I know it's speculative, I know, but it's possible that plea withdrawal, that the burden could be met of manifest injustice. And what is that something where the line should be drawn?
I think the line should be drawn as the court has said at entry of plea and sentencing, because just for as a practical matter, otherwise the Fifth Amendment right is never extinguished. I mean, I understand that too. Yeah, I mean, it just seems that there at some point some practicality has to enter into the
What's
equation.
so bad? What's so awful about that? That the right would not.
Well, it makes no
Quote,
sense
unquote,
because
extinguish.
if he said he's gone into open court and pled guilty, so I did this. I mean, at that point, I mean, he's incriminated himself. What more adverse consequence could happen than that? And then you're saying, well, but we're even though he said that, because it's possible sometime down the line that might get, I mean, that statement in open court, his incriminating statement made in open court, I don't know, it doesn't make any sense that that he's made that statement in open court, and yet he retains the right to later say, oh no, I can't testify about that because I might incriminate myself. I was like, dude, you already did that. You incriminated yourself in open
Well,
court.
so long as he has available to him a legal pathway
But there's always,
Upend.
there's always, I mean, you could, like I said, you could stretch that on into multiple successive 1507s and federal habeas petitions ad nauseum, and it never ends. I mean, at some point, we have to be intellectually honest and recognize that we need a practical rule.
Well, the Fifth Amendment is the opposite of practicality. That's the whole point. It says the government can't coerce someone to be a witness against themselves. That's, I mean, if you wanted
Well, that's,
practicality, you
but
just
once
go
the,
back.
once the man has gone into open court and said, I did it, I mean, I think at that point, he accepts the fact that his right is going to terminate. I mean, it's a trade-off. And with all.
Talking
we do
about
that
it
with-
almost like a waiver.
it is a waiver. I mean, we do that with all the constitutional rights, that none of them are absolute. There's always some limitation generated by practical necessity. There are no further questions, and I would simply ask to from the lower court. Thank you.
May it please the court, just briefly, unless there's more questions, I want to follow up on the question I believe that was asked about the Mitchell case on no adverse consequences. And I think that's a very valid point in that for the fact that he can't be sentenced again doesn't mean that there's not going to be other collateral adverse consequences. Should somebody be compelled to testify against their Fifth Amendment right, should they deem that appropriate? Additionally, another issue was brought up, I think, about, while it's extraordinarily uncommon for somebody to show manifest injustice after sentencing, it does happen. Go back to the DNA example, or, some sort of horrendous other fact scenario, it is possible. And again, somebody being compelled to testify and not be allowed their right to invoke their Fifth Amendment rights can be an adverse consequence, although it may be rare, it is possible.
Well, aside from the realm of the possible and the speculative and tests that may or may not be developed later, what about the waiver argument? Since he has done the ultimate self-incrimination by pleading guilty, has he waived his Fifth Amendment right?
That was a very interesting argument brought up by the state. If that's something that the court's going to find, perhaps that's something that should be added to the list of questions at an arraignment. When somebody is entering a plea, that they understand that they're waiving their Fifth Amendment right to assert their innocence in the future. I think,
Isn't
Fifth
that
Amendment
obvious?
right,
I
I'm
mean,
sorry.
Isn't it obvious that they're not exercising their Fifth Amendment right in the
No,
ultimate way?
No, I would say in dealing with most criminal defendants, absolutely not. That's not obvious. You would need to be extraordinarily clear about that. I can't tell you how many clients have pled guilty and still assert their innocence. I mean, we all know that happens, that people plead guilty and still assert their innocence. So I think it would need to be spelled out very clearly and very carefully, if that's what the standard that we're going to hold criminal defendants to, that if you're going to plead guilty, you need to understand you can be called as a witness to testify as to what you did or did not do in this matter. Again, the Fifth Amendment right is one of the most important, if not right at the top of the important amendments that we have to not incriminate ourselves. And I think we need to be very careful and very carefully spell that out, not only for attorneys such as myself in the state that are dealing with this issue before the court today, but also for our folks that find themselves in the criminal system. So, any other questions? Thank you very much.
Thank you. Thank you to both counsel for your arguments this morning. The court is now in recess until 9 a.m. tomorrow morning.